use the gavel. I just don't think it's appropriate for a chair to have a gavel.
I had a great night's sleep.
Yeah, I know. You ready?
Maybe
All right.
I'm terrible.
Good morning and welcome to Judiciary Committee. My name is Senator Justin Wayne. I represent Legislative District 13, which is North Omaha and Northeast Douglas County. I serve as the chair of Judiciary. First, we'll start off by having committee members and staff do self-introductions, starting with my right, Senator Ibach.
Thank you, Mr. Chairman. I'm Teresa Ibach, District 44, which is 8 counties in southwest Nebraska.
Good morning, Terrell McKinney, Senator District 11, North Omaha.
Good morning, Suzanne Geis, District 25, which is the east side of Lincoln and Lancaster County.
Josh Henningsen, Committee Leader.
Hi, everyone. My name is Wendy DeBoer. I represent District 10 in Northwest Omaha.
Rick Holcroft, District 36, West and South Sarpy County.
All right. Also assisting us is our committee pages, Morgan Baird from Gearing, who is a political science major at UNL, and Chrissy, right, Golseth from Omaha, who is also majoring in political science at UNL. This morning, we'll be hearing 3 bills. They'll be taken up in the order listed outside the room. On the table in the back of the room, you'll find blue testifier sheets. If you are planning to testify today, please fill out a blue testifier sheet so we can make sure we have accurate records. If you do not wish to testify but want to have your record record your presence at this hearing and a position at this hearing, please fill out the gold sheet in the back of the room. Also, I will note it's legislature policy that all letters for the record must be turned in by noon the day prior to the hearing. Any handouts, please make sure you hand them to the pages to make sure we have an accurate account. Testimony will begin with introducer's opening statement, followed by proponents, supporters of the bill, then those who oppose, followed by those speaking in neutral capacity. The introducer will then be given an opportunity to make a closing statement. We ask that you begin your testimony by first stating and spelling your first name and last name for the record. We will be using the 3-minute light system, so when your testimony begins, you'll be green, yellow is 1 minute, and the red light, we will ask you to wrap up your thoughts. I would like to remind everyone, including senators, to please turn off or silence your cell phone or put them on vibrate. With that, we will begin today's hearing with LB 220. Senator Ibach, welcome to your Judiciary Committee.
This is a great chair compared to some of the other hearing rooms. Thank you, Mr. Chairman. Good morning, fellow members of the Judiciary Committee. My name is Senator Teresa Ibach, Teresa Ibach, and I represent Legislative District 44. Today, I'm here to introduce LB 220 for your consideration. LB 220 is a simple bill that seeks to strengthen the rights of Nebraskans who are victims of crimes. LB 220 requires the Board of Pardons to notify a victim whose name appears in the file of a convicted person via certified mail of any pardon or commutation proceedings at least 90 calendar days prior to the proceedings and within 10 days if a pardon or commutation has been granted. This will ensure that victims of crimes are notified in a timely manner, and there's a record that the notification was delivered or a bona fide delivery attempt was made. For background, in 1996, the Nebraska Constitution was amended and provided victims of crimes additional rights. Article 128 states, 1, a victim of a crime, as shall be defined by law, or his or her guardian or representative shall have the right to be informed of all criminal court proceedings, the right to be present at trial unless the trial courts find sequestration necessary for a fair trial for the defendant, and the right to be informed of, be present at, and make an oral or written statement at sentencing, parole, pardon, commutation, and conditional release proceedings. Excuse me. This enumeration of certain rights for crime victims shall not be construed to impair or deny others provided by law or retained by crime victims. And number 2, the legislature shall provide by law for for the implementation of the rights granted in this section. To ensure victims are notified per their constitutional rights, LB 270 was enacted into law in 2004. This bill amended Nebraska Revised Statutes 81-1850 to include language that states, "A victim whose name appears on the file of a convicted person shall be notified by the Board of Pardons, A, of any pardon or commutation proceedings, and B, if a pardon or commutation has been granted, and tasks the Board of Pardons to adopt rules and regulations if necessary to carry out the provisions of this section." I read news articles that Nebraskans who are victims of a crime have not been notified prior to the pending hearing or if a pardon has been granted, leaving these victims to find out after the fact, which is why I'm seeking to strengthen these provisions today. I am also submitting AM 335 for your consideration. AM 335 further strengthens the intent of this bill by automatically including the name and address of the victim in the file of a convicted person unless the victim makes the conscious decision to opt out of further notifications. After receiving the fiscal note yesterday, I did not understand how LB 220 had zero fiscal impact. The fiscal note submitted by the Nebraska Commission said, "No fiscal impact due to the fact that the Board of Pardons does not have access to the information needed for victim tracking." This makes me think that there may need to be additional tweaks to LB 220 to ensure that the Board of Pardons will be in compliance with the statute that was enacted 19 years ago. And I'm willing to work with anyone to ensure that this happens because this is that important. Additionally, during my research for this bill, Nebraska Revised Statute 83-127 already required the Board of Pardons to make rules and regulations for its own administration and operation. However, these rules and regulations do not appear to be public. LB 220 would require the Board of Pardons to make public these rules and regulations to improve government transparency. With that, I thank you for your time, and I will entertain any questions.
Any questions from the committee? Seeing none,
Thank you.
thank you.
Thank you, Mr. Chairman.
First proponent. First proponent.
Good morning.
Welcome.
My name is Jody Snogren, Snogren. I come before you today because someone who committed a violent crime against me received a pardon in September of 2022. I found out about the pardon by accident 1 month later in October of 2022. In the spring of 1993, my estranged husband, John Arias, came into my home, tied me up with parachute cord, gagged me, and violently raped me, repeatedly while threatening to kill me with a hunting knife, while our small children and my nephew were in the next room. He told me his intent that night was to kill me, and I believe him. I was 28 years old. The details of that night and the years of abuse that led up to it still haunt me 30 years later. John Arias committed multiple felonies and faced lengthy sentencing. He was offered a plea agreement, which dropped several of the charges and kept him from facing a jury, with the caveat that he would remain on the lifetime sex offender registry. The judge sentenced him to 15 to 30 years in the state penitentiary. During his imprisonment, he continued to torment and threaten me. When he became eligible for parole or was ever outside of the prison walls, I was alerted by the Vine system of notification. He was released after spending the maximum sentence with credit for the good time served rule. Not once in 30 years has John Arias offered remorse to me or our children. In fact, he has done just the opposite by stating at one point that I deserve what I get and that I should watch my back for the rest of my life. Never in my wildest dreams would I have thought that number one, he would be eligible for a pardon, and two, that he would be granted one. Most importantly, the pardon was granted without my concern or with any concern for the person who was violated, me. I was not at the pardons meeting in September because I had no idea it was happening. No one considered that the one person who might be most affected by the pardon should be contacted. I have lived in the same house for 27 years, have the same address and cell number. Former Governor Ricketts and former Attorney General voted for the pardon with biased lies and info. Now Arias is removed from the sex offender registry, can vote, and own a firearm. Trauma of the magnitude that Arias inflicted does not just go away. I spent years in counseling and struggled with PTSD. One act, the pardon, brought all that back with awful nightmares and memories. I went back to counseling in November, had cameras installed in my home, and contacted law enforcement where I live. His violent acts were forgiven by the state of Nebraska. His rights were restored. I ask you, where do my rights fit in?
Ma'am,
I'll-
I'm going to ask you to stop.
Okay.
Senator Geis.
I don't even know what to say. I'm just going to let you finish what you had planned to say.
Okay, thank you.
Mhm.
I'll be honest, the entire pardons process tests my belief in the process of law. That is not the issue today. The issue is LB 220. It will require the Board of Pardons to notify the victims of the crime at issue by certified mail 90 days ahead of the proceeding. I believe I have the right to be informed and to be present to make any concerns known, or to, in the very least, make a statement of my concern. And I would just like to thank Senator Ibach and you all for allowing me to finally have a voice.
And I'll say, I believe you have that right at a minimum. So thank you for
Thank
your
you.
testimony.
Any other questions from the committee? Senator DeBoer.
I just want to say thank you for being here and pointing out this problem in our system. And I hope we can work together to get this figured out.
Thank you. Me too.
Any other questions from the committee? Seeing none, thank you for being here.
Thank you.
Next proponent.
Good morning, Chairman Wayne and members of the Judiciary Committee. My name is Beth Lynn, Bethlinn. I am speaking to you today in support of LB 220 because of the recent events of the utilization of a nonprofit veterans organization by a convict to obtain a pardon, which removed him from the sex offender registry. The victim only became aware of the hearing and the resulting pardon because we, the What About Us rally group, announced in public media across the state that we were protesting this action. I was contacted by the victim, which is when I found out she had not been notified by the pardon board. The resulting impact on her and other victims across the state is what made it clear to us that the pardons board is in need of more oversight, that the victim's ability to protect themselves is seriously compromised by the current legislation. LB 220 is the first step in the right direction to protect the victims of crime. We want to thank Senator Ibach for recognizing the serious errors in previous legislation, and we hope you guys do pass this.
Thank you. Any questions from the committee? Seeing none, thank you for being here.
Thank you.
Next proponent. Any opponents? Any opponents? Anyone here testifying in the neutral capacity? Testifying in the neutral capacity. For the record, we received 2 letters of support. Senator Ibach, you're welcome to close.
Thank you, Mr. Chairman. I would just like to say thank you for those that came today and testified in favor of this. This really is just to hold the Board of Pardons and the and the Department of Parole accountable. And I think this legislation will do that. So I appreciate your support. I appreciate you listening. Thank you.
Yes, Senator Rice.
I'm just shocked, I guess, that this isn't happening. And it appears that it should be.
It really is just to hold them accountable and make sure that this is happening, because it's not.
Wow. Okay, well, thank you for bringing this.
It's an awareness issue. And, you know, as you heard the testifiers, it is a real issue. And I just hope that this maybe cleans up some of the language and really holds them accountable.
Yeah. Thank
It's
you
an
for
easy
bringing
one. All right. Thank you.
Any other questions from the committee? Seeing none, well, this will close the hearing on LB 220, and now we will open the hearing on LB 757. Welcome to your Judiciary Committee, Senator DeBoer.
I'm surprised you got. That's a whole other issue, but. Some people, could we discuss a pardon?
Welcome.
Good morning, Chair Wayne and fellow members of the Judiciary Committee. My name is Wendy DeBoer, W-E-N-D-Y-B-E-B-O-E-R, and I represent the 10th Legislative District in Northwest Omaha. I'm here today to introduce LB 757, which will make changes to the application process for the Crime Victims Reparations Fund in a few different ways. Last session, my office introduced Legislative Resolution LR 412 to examine if protections and programs afforded to crime victims and survivors are adequate. After surveying victim assistance programs and direct service providers across the state, it was clear that improvements must be made to programs that serve crime victims. More specifically, providers noted how critical it is to improve the Nebraska Crime Victims Reparations, or CVR program, for victims and survivors by providing transparency throughout the process, ensuring funds are distributed efficiently and equitably, and lifting barriers that make it difficult for victims to access funds. LB 757 seeks to address both the efficiency of distribution and the lifting of barriers to accessing CVR funds. For background, the CVR was created in 1979 after the passage of LB 910 to provide financial support to innocent victims for certain expenses related to a reported crime, as determined by the hearing officer. Eligible applicants include innocent victims, family members of innocent victims, or anyone who is injured as a result of helping an innocent victim. Applicants may be granted compensation for a variety of expenses up to $25,000 per incident as a result of the crime, including medical expenses incurred as a direct result of the crime, loss of wages while under a doctor's care as a direct result of the crime, funeral expenses as a direct result of the crime with a maximum there of $5,000, loss of earning power as a direct result of the crime, and counseling expenses as a direct result of the crime, and that is capped at $2,000. Per Nebraska Revised Statute 81-1821, to be eligible for the funds, the victim or applicant must have submitted the application within 2 years after the date of the personal injury or death, and the personal injury or death was the result of an incident or offense which has been reported to the police within 3 days of its occurrence. An exception to the 3-day reporting requirement is made for victims of domestic violence, sexual assault, and child abuse who have obtained a protection order related to the incident. Reported to the crime to police anytime before applying to the CVR program, or have presented for a medical forensics exam related to the incident. Funding for the CVR program comes from various sources, including state general fund appropriations consisting of 5% of offenders' wages who are employed in the federal prison industries program, a $1 court fee for each misdemeanor or felony conviction, with up to 5% of net wages of inmates assigned to the Department of Correctional Work Release Program. Federal funds also account for a portion of the program's funding. The federal funds that are available vary from year to year, with the federal award estimated to be about 60% of the state funds expended during the previous fiscal year, meaning that Nebraska's inability to distribute funds efficiently through the state's program has the potential to reduce the state's future funding because it reduces the state's federal funding. I introduced LB 757 in order to start addressing just a few of the very serious problems associated with the CVR. As we've heard before in this committee, this legislature and the state have already decided that we care enough about victims of these crimes to ensure that they have access to the health care and services they need to recover. The proposed changes in LB 757 are based in victim-centered, trauma-informed best practices and were developed in consultation with victims, victim advocates, and experts in the field. These changes are intended to fulfill our promise as a legislature and a state to protect and help innocent victims of these crimes. So I appreciate the committee's willingness to help us reach that goal with LB 757. So I'm happy to take any questions.
Any questions from the committee?
I will say I handed out for you the report of my LR this summer so that you have that report that we created as part of the LR.
Seeing none, thank you for being here. First proponent. First proponent. Welcome.
Thank you. Chairperson Wayne, members of the Judiciary Committee, my name is Erin Feichtinger, ERINFEICHTINGER, and I'm the Policy Director for the Women's Fund of Omaha. We are committed to ending gender-based violence in this state, and as such, we worked closely with Senator DeBoer's office on LR 412 to identify gaps in our current programs, serving victims, and to identify opportunities to improve those programs. LB 757 is an important step towards those improvements, specifically the Crime Victims Reparation Program. As Senator DeBoer stated, we intended to identify gaps in the services and funds specifically that the state uses to help victims of domestic violence, sexual assault, and child abuse. Victim assistance programs serving victims of those crimes from across the state provided feedback, and most of those responses centered on their experience with the Crime Victims Reparations Program, or the CVR. While some strengths were identified in the process, including the ability of healthcare providers to directly bill the CVR for services, the overwhelming majority of respondents expressed frustrations with the inefficiency of the program, its lack of transparency, and the lack of a trauma-informed response to victims in their attempts to access that funding. We cannot fix everything at once, but LB 757, as well as other bills heard in this committee, like LB 315, are important steps toward making sure that victims of these crimes are well served by these services in the way that this legislature has intended. Specifically, LB 757 addresses the strict eligibility requirements currently utilized in the CVR process that has unfairly disqualified victims and their families from receiving the funds they would otherwise receive if the process was more flexible so as to be trauma-informed and victim-centered. The existing eligibility requirements provide no room for a trauma-informed approach to victims and their families, which often results in re-traumatization of victims and serious financial consequences for them. Multiple respondents cited an overly strict interpretation of eligibility requirements for compensation as another problem with the CVR program. The funding timeframe and model does not serve many survivors and victims, especially those who have experienced sexual assault or child abuse. Research shows that few victims of these types of crimes seek assistance immediately following the incident and may choose to disclose years later, if at all. Furthermore, victims who are minors at the time of the incident may not have the appropriate resources to navigate the CVR program. And one solution to help these victims in the short term is to extend that 2-year timeline to apply to the program and provide flexibility on a case-by-case basis. While not specific to the changes in LB 757, it is important to note that changing the eligibility requirements may also help us start to address the serious concerns around the disconcertingly high rate of denials from the program and the incredibly long processing times for the CVR. The CVR program is quite simply not operating as the legislature intended, and victims as well as healthcare providers are being left to bear the burden of a program designed to help them, currently failing in almost every way to do so. I am happy to take any questions you may have.
Any questions from the committee? Seeing none, thank you for being here. Next proponent. Next proponent.
Good morning. My name is Kristen McTaggart, CHRISTON, last name MACTAGGART, Chairperson Wayne, members of the Judiciary Committee. I'm here on behalf of the Nebraska Coalition and our network of sexual and domestic violence programs across the state to testify in support of LB 757. Our network of 20 programs collectively serves all 93 counties in Nebraska. We are the primary service providers for domestic and sexual violence survivors. Last year, our network answered over 36,000 crisis calls, and they met with and provided direct support to almost 12,000 victims. These individuals often have a spectrum of challenges related to the trauma they've experienced. It could include mental health issues, medical bills from physical injuries, costs related to property damage from an abuser, loss of wages that impact their ability to maintain housing, vehicle, childcare, et cetera. The list goes on. It could include one of those things, it can include multiple things. The Crime Victims Reparations Fund is a resource that's utilized by our network of programs to support these individuals. That said, the process is lengthy and it can be cumbersome for the people that are using it, especially for individuals who are already navigating all of these previously mentioned things. Many survivors would not be able to navigate it at all, or would have significant difficulty if they didn't have somebody to walk them through it and provide support along the way. So these changes in LB 757 are an important step towards not tying up or denying requests for assistance that are based on technicalities that often have nothing to do with the need or the validity of the application. They're small trauma-informed changes that we believe will have a large impact on the process and the ability of survivors to access it. As a state, we have to create processes that are accessible for the people that are using them. And currently this process is not a trauma-informed process. Victims need systems set up to support them, and because all trauma looks different, they really need systems to allow for flexibility. So for that reason, I urge you to advance this out of committee, and I'm happy to answer any questions you might have.
Thank you. Any questions from the committee? Seeing none, thank you for being here. Next proponent. Next proponent.
Good morning, Senator Wayne and members of the Judiciary Committee. My name is Ivy Svoboda, IVY-SVOBODA. I'm the Executive Director of the Nebraska Alliance of Child Advocacy Centers, here testifying in support of LB 757 to extend the eligibility timeline for applicants of crime victim reparations funding for children and families who experience child abuse, domestic abuse, and sexual assault, ultimately reducing the barrier to access. The Nebraska Alliance of Child Advocacy Centers is the nationally accredited membership organization for the 7 Child Advocacy Centers, or CACs, which will serve children and families and the protection system for all 93 counties within our state. We're dedicated to enhancing the response to child abuse. Our CAC members provide trauma-informed services to children and families we assist with investigations of child abuse and neglect. In 2021, Nebraska CACs served 7,800 children for a range of reasons, from sexual assault to witnessing domestic violence and physical abuse. For those seen at the centers, our CAC advocates made over 30,000 contacts throughout that year. That's 30,000 contacts in which the CAC advocates worked with caregivers to answer questions, offer guidance, provide counseling, crisis assessment, intervention, and referrals from mental health, public assistance, protection orders, and legal services. Through our national accreditation, the CAC advocates are required to provide education to ensure that families are informed of their rights as crime victims and are required to provide assistance in ensuring access to crime victim compensation. The CVR funding provides an important support to ensure children and families are able to afford services needed for healing and justice and pay fees and bills incurred due to experiencing crimes. Currently, a victim who is a minor during the time of a crime must apply to the CVR program within 2 years. LB 757 would expand the timeline to make survivors eligible to apply on or before their 22nd birthday or within 3 years of their death. It would provide for minors at the time adopting trauma-informed best practices. There's no statutory limit on prosecuting child sexual assault cases. This lines up with research that shows that most people who experience sexual abuse in childhood do not disclose until well into adulthood. 757 creates consistency through the CVR program to ensure that minors are provided a timeline for applicants more compatible with the prosecution timeline. Thank you, Senator DeBoer, for introducing this important bill, and we respectfully.
Any questions from the committee? Seeing none, thank you for being here today. Next proponent.
Good morning, Chairperson Wayne and members of the Judiciary. My name is Annie Boatright, ANNEBOATRIGHT, and I am a registered nurse and the State Forensic Nursing Coordinator, Sexual Assault Payment Program Administrator for the Nebraska Attorney General's Office. I appear today on behalf of the Attorney General's Office in support of LB 757, As the State Forensic Nursing Coordinator and Sexual Assault Payment Program Administrator, I set best practice standards around sexual assault, domestic violence, sex trafficking, and child abuse neglect. I also serve on the Crime Victim Reparations Board Committee as a public member who has expertise working with victims of crime. In the last fiscal year, our sexual assault payment program reimbursed hospitals and CACs for 1,467 medical exams statewide. 988 of these were on children aged 0 to 12, 988 of these examinations were medical exams for children. 588 occurred on children between the ages of 0 to 12, and 400 on ages 13 to 17. Currently, the reporting window to law enforcement is 72 hours for crime victim reparation claims, while our acute sexual assault examinations with evidence collection are performed up to 120 hours after a sexual assault. Our evidence collection standards have been in place since our creation of the standard sexual assault kit, which was enacted in 2017. LB 757 aligns that state law with best practice standards. 757 also allows children of sexual assault the opportunity to file a claim for 3 years after they reach the age of majority. We know that the need for mental health services goes beyond the existing time frame for a reported crime, and the impact of these acts act a lifetime. I have seen firsthand parents who have been informed of their CVR eligibility just beyond the 2-year requirement to receive reimbursement for mental health services for their child. This legislation supports victims by allowing them the time they need to process the true needs they have and act accordingly. We invest in the outcomes of our fellow Nebraskans, giving them the opportunity to move beyond victimization in these long-term cases. These crimes are ones that I hope no one must ever experience, but we must support the people that are forced to walk along this path. I respectfully request that you advance LB 757 to general file, and thank you and welcome any questions you may have.
Any questions from the committee?
Yes.
Senator Obama.
Thank you, Chairman Wayne. Thank you for your testimony. I noticed in one of the handouts, it says the maximum award per incident is $25,000. Is that correct?
That is correct.
Is that adequate? Have you seen? I mean, is it, should we be putting more into this fund?
So I will tell you that $25,000 to cover mental health services, medical costs and everything, I don't think is really truly adequate, but I also understand that there has to be limits on fiscal impact. And so we do what we can to support victims with the funds that we have. So I think that it would be a good idea and it would be in line with national best practice to increase those amount funds.
Thank you.
Any other questions from the committee? Seeing none, thank you for being here.
Thank you so much.
Next proponent. Next proponent. Any opponents? Any opponents? Anybody testifying in neutral capacity? For the record, we received 5 letters of support. Senator DeBoer, you may close.
Thank you, Senator Wayne, and thank you all for this hearing. I just wanted to be crystal clear that there are basically 3 discrete changes that this makes to the CVR program. I realize I didn't list them in my intro. So the first is it allows, and as you've heard, minors to apply to the fund up to 2 years after achieving majority. Right now, if you have a minor who gets assaulted, say as a 5-year-old, and nobody can detect that or realize that or understand that because they're not able to communicate it, then by the time they're 7, their ability to apply for the fund is gone. Whereas if they discover it and can report it at 8, now they can't apply for the fund. So that means that if they need care in terms of probably not immediate medical care in that situation, but mental health care and those kinds of things, they're just not eligible to get any funds from the fund, which kind of goes against the whole purpose of it. And then moving, as you heard Ms. Boatwright say, moving from 3 days to 5 days for the initial reporting, and that is because it turns out that we can do those forensics kits for 5 days, and so that will match with that. And then allowing a good cause exception, because there are extraordinary circumstances from time to time that would allow someone to maybe 2 years and 1 day apply to the fund, and this would allow the hearing officer to say, okay, there's a reason why you didn't apply to this, and now you have, and in this case, we understand that, and we're going to understand that we're going to allow it in this case. It still keeps the discretion with the hearing officer, but it allows for that exception so that they're not just statutorily cut off without any ability to kind of figure out what the right thing to do is. So those are the 3 changes that this makes to the CVR fund. And, you know, I brought this bill not just because of the LR. I brought this bill because I was told the story of a little girl who was assaulted by her stepfather and repeatedly, and her father, her birth father, found out, and they applied, and it was literally 2 years and 1 day. So we can do better than that. Thank you.
Thank you. Any questions from the committee? Seeing none, thank you for being here, and that will close on LB 757, and we will open the hearing on LB 760. Welcome back, Senator DeBoer.
Thank you, Senator Wayne. Good morning again, Chair Wayne and members of the Judiciary Committee. I feel like I was just here. My name is Wendy DeBoer, W-E-N-D-Y-D-E-B-O-E-R, and I represent District 10 in Northwest Omaha. I'm here today to introduce to you LB 760, which instructs the Nebraska Commission to create a grant program for victim advocate training. Victim advocates serve a vital role. They help victims get assistance, whether it be medical assistance, housing help, resources, or just being someone who's on their side during the stressful criminal justice process. If a victim feels supported, helped, and heard, they are much more likely to work with the county attorney's office in the prosecution of the crime. Depending on the county, there might be a victim advocate on staff in either the police department or in the county attorney's office, or maybe both. However, in our small counties, this role falls on a police officer or a county attorney who may have no training on victim advocacy, and this can result in victims deciding to no longer cooperate with the investigation or the court case. That's why in 2011, Creighton University, using funding available to them from the DOJ Office of Victims of Crime, created the Nebraska Victim Assistance Academy, or NEVA. For some background on what NEVA is a 5-day, 40-hour accredited training academy tailored to the needs of Nebraska's victim advocates and allied professionals. NEVA is approved for 40 hours of continuing law enforcement units or continuing education units for social work, mental health providers, or other behavioral health specialists and lawyers. The federal funds that supported NEVA in its original form ran out in 2014. In 2015, they ran the program at Creighton without any funding, then received federal funding in 2016 to 2018, which ran out again, and Creighton operated NEVA without any funds directly supporting this important training in 2019 to 2021, at which point they had to stop hosting the training. The University of Nebraska Omaha took over administering the program, and the Crime Commission was able to use leftover federal VOCA dollars to help support it. This support was especially helpful as it provided reimbursement payments for attendees who had to travel across the state to access the training, so we can get it to other parts of the state as well. As the training is a week-long training, being able to pay for a hotel is a must for those who are attending who do not live in the metro areas. Unfortunately, those VOCA dollars are no longer available to support this training. That's why I introduced 760. I firmly believe we need to be sure we are properly supporting victims in Nebraska in any way we can, and that includes ensuring a workforce that is trained to work with the victims in the best way possible. So whether the training is done by NEVA or another entity that provides such training meeting the qualifications of LB 760, we need to support our victim advocates and victims with a state investment in a training program. Dr. Tara Richards, who currently coordinates NEVA, is here to testify and can provide more information on the background of NEVA and how it currently operates. Importantly, she will stress the importance of sustained funding for this training. And she, along with others, can also speak to the importance generally of having properly trained victim advocates across the entire state. So thank you for your time, and I'm happy to answer any questions you may have and urge you to advance LB 760 to general file. This is maybe too much information, but I will tell you, I have had a victim advocate before, and it made an incredible difference with the process for me and working with the police officers and the prosecution.
Just a quick question.
Senator Geis.
And just a quick question to clarify. So the $50,000 grant would come from the gym. I'm reading it right here. Forget it. I answered my own question. Thank you.
Yes.
Yes. Thank you.
Any other questions from the committee? Senator Ibach.
Thank you, Mr. Chairman. My question goes to the 50,000 as well. Do you think that's enough? I mean, well,
I think that someone behind me can answer that better, Dr.
Okay.
Tara, but I believe that's why we asked for that amount. was that
Okay,
it was
thank
supposed to
you.
be enough.
Any other questions? Seeing none, thank you for being here. First proponent. First proponent.
Good morning, Chairman Wayne and members of the committee. My name is Dr. Tara Richards, and I'm an associate professor in the School of Criminology and Criminal Justice at the University of Nebraska, Omaha. That's Tara, T-A-R-A, Richards, R-I-C-H-A-R-D-S. But please know this is my testimony, and I'm not testifying on behalf of the Nebraska University of Nebraska system or the University of Nebraska at Omaha. Thank you for allowing me to testify in support of LB 760. As noted by the senator, victim service providers and allied professionals work in a variety of settings, both state agencies and other community and faith-based organizations. The increasingly complex needs of crime victims demand more coordinated and multidisciplinary approaches to training these victim-serving professionals. The passage of LB 760 would establish sustained funding for the Nebraska Victims Assistance Academy, Nebraska's only accredited statewide training tailored specifically to the needs of Nebraska's victim-serving professionals. I have the privilege of leading the steering committee and coordinating this training, so please allow me to tell you a little bit about our state's academy. Local instructors present the latest research, state legislation, and practical resources to provide continuing professional development to those serving victims of crime in our state. For example, the curriculum includes fundamental education on ethics and trauma-informed communication, as well as ever-changing topics such as human trafficking and cybercrimes. We also discuss the effects of legislative changes on victims, such as the impact of LB 320, which expanded eviction protections for domestic violence survivors. As noted, our rigorous curriculum has been approved for continuing education units for many service providers, from law enforcement officers to victim advocates. But we cannot provide this training without consistent and sustained funding, and that has been a journey. Using a fee-for-service model would put the academy out of reach for most of our smaller agencies, and as noted, most rural providers really need additional financial support to travel to the academy. We do not want the academy to become a training that's only accessible to our metro areas, because the academy really is an opportunity for professionals from across different types of agencies, from the most rural jurisdiction to the most urban jurisdiction, to work together, to learn from each other, and build their community of practice. The professional networks that are built in the academy can provide critical support to Nebraska's helping professionals who are in fields that have some of the highest rates of compassion fatigue, burnout, and turnover. This really is a workforce development issue because we cannot afford to lose these folks from these positions. They're so important in the work that they do. In sum, I am in support of LB 760 because it would provide that state sustained funding for Nebraska's only accredited statewide training for victim service professionals. These folks really are some of the most dedicated and hardworking professionals in our state, and they deserve the best preparation and training. I urge the committee's favorable support, and I'm happy to answer questions.
Any
Thanks.
questions from the committee? Seeing none, thank you for being here.
Thank you.
Next proponent. Next proponent. Next proponent. Welcome.
Thank you. Chairman Wayne and members of the Judiciary Committee, my name is Natalia Tu, Nataliatu, and I am the Research and Policy Associate at the Women's Fund of Omaha. As you heard earlier, we are committed to advancing gender equity, and that includes working toward freedom from gender-based violence for all Nebraskans, so domestic violence, sexual assault, human trafficking. And we understand how vital comprehensive training is in this line of work to ensure that all systems professionals and advocates who work closely with survivors in our state have a coordinated, multidisciplinary, and most importantly, trauma-informed approach. As such, we offer support for LB 760, a bill that will help ensure the sustainability of critical training programs in our state. So as Dr. Richards outlined, each year, the Nebraska Victim Assistance Academy, or NEVA, provides 40 hours of training to a very diverse group of attendees from across the state. So this includes family advocates from child advocacy centers, domestic violence advocates, victim witness advocates, and of course, law enforcement and therapists as well. It's a pre-approved A-level training, and it's also the only one in our state that offers this certification. But beyond certifications and certifications, NEVA provides a broad and rigorous core curriculum that covers issues of domestic violence, child maltreatment, and human trafficking. And attendees learn how to best support survivors and victims in a trauma-informed and culturally sensitive manner. This training is taught by local professionals. In fact, one of our colleagues, Nick Zadina, who couldn't be here today, has been one of the trainers since NEVA's inception in 2013. And we know that this is particularly helpful for all attendees to attend because there's a foundational training that is set and can provide consistent support and services to survivors no matter what the professional or who they are affiliated with. And then beyond this foundational education, we know that NEVA helps foster community among professionals in this field. It's important for folks to have the opportunity to meet one another to help improve their understanding of each person's respective roles within the system. And this can be helpful later on for referrals or if there are coordinated efforts that need to be made in regard to cases. And most importantly, it's important that folks have a space to come together, learn from each other. We know that systems professionals suffer from secondary trauma and burnout, and it's important to have that community. So funding for this program would mean investing in the professional development of those working most closely with victims in our state. And we urge you to support LB 670, to support the professionals in our state who are doing some of the most difficult and critical work. Thank you.
you. Any questions from the committee? Seeing none, thank you for being here today. Next proponent.
Hello again. My name is Kristen McTaggart, CHRISTON, last name MACTAGGART. I'm here testifying in support of LB 760 on behalf of the Nebraska Coalition and our network of 20 direct service programs across the state. You've heard a lot about the benefits of the Nebraska Victim Assistance Academy, why it should be in place, so I won't belabor those points. For you have my testimony in front of you. What I will say, though, is that as a victim service provider network, we know how important it is to have a consistent and a trauma-centered response when we are working with individuals. And the majority of victim serving networks across the state, and we are not the only one, obviously, but the majority of those networks outside of ours actually don't necessarily have standardized training or a backbone organization that's able to provide it. So the Nebraska Victim Assistance Academy meets this need for those networks, including those that are directly supporting victims of crime in our criminal system and our legal systems. It's crucial for the training to continue, and it's also really crucial for victim service programs to be able to easily access it, which without these funds will not necessarily happen or will not be accessible for them. So we support this bill. We would ask you to advance LB 760 out of committee. I would also share that I've been a past trainer for the Nebraska Victim Assistance Academy. I was also on the steering committee when it was originally created. So I've been part of this process for a very long time. I'm happy to answer any questions that you might have about it.
Any questions from the committee? Senator Ibach.
I just have one for you. How many folks do you have in place across the state that actually participate in the program?
So we do you mean with our network specifically?
Yes.
So our network of 20 programs, we have a mandatory 40-hour training that our organization provides as the backbone organization that they are required to go through. It's 40 hours, some of it's virtual, some of it's in person. However, a number of our advocates also go through this because it has a criminal lens and they do lots of legal advocacy, and it also allows them to network with other victim service providers outside of our network, which they work with daily. So it's also really important. So I don't know the exact numbers of how many people from our network specifically attend. I would say generally for most academies, they have around 50 people or so that go through it each year that, again, are from all different areas of the state.
And it, like you said, it is virtual and in person.
So NEVA's in person.
Okay.
When I was talking about, we have a separate training that folks are required to go through. That's 40 hours that are just for the advocates in our network. But then in addition, a lot of them also go through NEVA for the reasons I mentioned. NEVA is an in-person training. That in-person piece I do think is really important. We'll never move our training to completely virtual format because the ability to network and connect with other folks is just, you can't really replace that, I think. So NEVA is an in-person training. They do have a portion of it, I believe, since COVID, that is sort of some, and Dr. Richards would be the better person to answer this, so I'm happy to get you this information afterwards. But they do have a portion of it that folks go through ahead of time that is virtual, and then they do the in-person training. So that was confusing because as I was talking about it, I remember that they actually have a virtual version to it. So I apologize for that.
Okay, thank you very much. Thank you, Chair Wayne.
Senator Geis.
So just so I'm clear, it's 40 hours of training to start, and then ongoing, how does that look annually?
So that is a good question. NEVA also does provide some continuing education pieces. Historically, they have done that. So they'll do everything from something that's a couple hours or maybe a day, and then they will provide some continuing education also. I sometimes think that with as many virtual trainings, some of that continuing education is a little bit easier to access than that really core foundation training that folks need to know when they are really starting or digging into this.
But this, what we're specifically talking about is just the 40 hours
40-hour
mandatory.
foundation training,
Okay.
correct? Yeah.
Thank you.
Any other questions? Seeing none, thank you for being here. Next proponent. Proponent. Any opponents? Any opponents? Anybody testifying in neutral capacity? Welcome back. We have 4 letters of support for the record.
Thank you very much. I've got a couple of answers to some questions I heard. One is that it's entirely in person. There's no online portion. That happened, I guess, a portion of that during just COVID itself. During that time, they had a portion that was online. But this is a completely in-person training, and it happens over 40 hours, like I said, kind of all at once. And it is $50,000 is the amount that will put us in line with Kansas and Iowa. So that's why it's $50,000. That's the amount that they have. I'm trying to think of any other questions that you all had. I know I'm forgetting something here, but if you can think of a question that I haven't answered, then I will answer it.
Any questions from the committee?
Okay, thank you.
With that, that'll close the hearing on LB 760 and close this morning hearing.